Currently, a bill that gives real teeth to unfair contract laws sits before federal parliament waiting to be passed. And what might appear to be a technical change to an obscure law known to very few people is in fact a huge step for fairness in how the Australian economy works. Everyone is affected, even if you understand how. And to discuss what the meaning of all of it is the CEO of Self-Employed Australia, Ken Phillips. Welcome, Ken.
Hi, Michael.
Morning, Ken. Now, this bill, once it's enshrined in law, what will it actually mean? What will the consumer notice?
Well, a lot of consumers, and this is directed at small business and consumers. And people need to understand it only applies to what are called standard form contracts, which are pretty big across the economy. So most insurance contracts are standard form contracts, just a standard form, here it is. And you really can't negotiate it. It's a take it or leave it situation. But it goes across all leasing arrangements, leasing equipment, so a small business leasing equipment, you name it, there are all sorts of things, IT contracts, it goes on and on and on and on. And very large numbers of larger firms are reliant on standard form contracts. So you sign a phone contract, you're signing a standard form contract. Now, the history of those sorts of contracts is that basically a lot of lawyers take the view, and I've got to say the big end of town lawyers, if you sign a contract that actually enables the other party to damage you, well, you signed that and good luck. Right? In other words, you went into it, you knew what was in there, and bad luck. In 2010, the Parliament federally introduced these unfair contract laws. And what it does, it puts limits around what can be in a standard form contract. So, for example, it's quite one of the provisions in there. There's about 10 or so provisions in the Act, which are quite specific. So it says that if one party has the right to terminate the contract without reference to the other party must have the same right. So if Telstra has the right to terminate the contract without talking to you, the standard form contract, you have to have the same right to also terminate the contract without talking to Telstra. And so there's a whole series of things here, and all very, very common sense. Another one is that if one party can change the terms of the contract, in other words, say the price of the contract, without referring to you and getting your approval, well, you have to have the same right. So what it does, it limits the capacity of big end of town mostly to put in place standard form contracts that enable them to screw over the consumer or the small business person. And in 2010, these came in for consumers. Then in 2016, we spent 7 years lobbying, advocating to get these same laws for small businesses. So they came into place for small businesses. But the contracts were limited to only contracts up to 300,000. So it meant that there's a whole range of contracts that fell out. The small business side of it was only for businesses up to 20, so really small businesses. And there are a whole lot of limitations on the ability of the ACCC, the Australian Consumer and Affairs Commission, to enforce these. So they had to prove that there was damage to the consumer or the small business, and they had to, the terms of the contract only became null and void. So they were just sort of eliminated. Now, what's happened is that ASIC, since 2016, was doing a lot of education of the big end of town on these, trying to do a whole lot of enforcement, took numbers to court and so forth and were winning, but essentially they were being ignored. And I've got to say, all dips and congratulations to Rod Sims, as chairman of the ACCC, who got up and said, "This is just not. I'm not satisfied with this. We've got to go further." And so he's been very heavily campaigning to take it further. So that's where we are today. So that's the background and where we are today. So the bill before the Parliament now makes unfair contract law clauses in standard form contracts illegal. It's illegal to have them once this bill passes. There are fines, heavy fines, for having unfair contract clauses. And on top of that, in terms of the enforcement area, a very, very important thing, it's not necessary to prove to the court that there was a damage to someone, say you. All the court has to see is that there could be a damage. In other words, look, what they're looking to do is close the stable door before the horse bolts, which is great. Further to that, there will be no limit on the size of the contracts. The limit goes, there's no limit. And the size of a small business is increased to a business with up to 50 employees or 50 workers. So what's coming through now is really super serious stuff. So if the large companies that rely on standard form contracts don't get their act together, will be in serious trouble. So this is quite a sweep through the economy. And from our perspective, what we're interested in is the free market. And the free market, the basis of that is small business. And this gives a new measure of power balance in contractual arrangements in the economy between small business and big business. And we say that's a damn good thing. It's a better economy, things work better, small business can get up and going. And frankly, large businesses who want to have standard form contracts have got to do their job properly and fairly and ethically. And this will push it on them, and so it should too. Yeah. So we're very, very pleased to see this. And there's been a unanimous view across the political spectrum. The support for this has been from all the political parties. I've got to give due credit to the Morrison government for driving this. It's been a long, slow, drawn-out process, but they've driven it. All the state governments have come in behind it, but also the Labor Party, the Greens, the Independents, everyone is, from what I can see, backing this very solidly. So this is a good story. Good story.
Great. And
there'll be some big businesses that won't like it. Bad luck.
Again,
Yeah.
great advocacy as usual from yourself and your organisation. So the onus comes back on to the business offering the contract. So as you pointed out, there doesn't have to be a wrong done. It's just basically, it can nearly be considered a conspiracy. Well, you've attempted to do it, so you've got to stop it in its tracks. How long will they give them for compliance? How long will big business have to run through all of their standard form contracts and have their legal team look over them and decide what is and isn't, or will the government outline?
Well, I've got to say they've had from 2010. They've had from 2010 to do this, and they've sat back and just gone, oh, well, we don't need to worry about it. I had a meeting back in about 2012 when we were doing our advocacy, and I went round to talk to the banks. And I had a meeting with the senior counsel from one of the banks, and we gave our little spiel. And the senior counsel looked at me and said, well, it's like this. We'll do what we're made to do. So, you know, they weren't interested in running ethical contract arrangements. Just, we'll do what we're forced to do. Now, I've got to say that National Bank and the Commonwealth Bank got on and fixed their contracts with small business in this area pretty damn quickly after 2016. I was very impressed. I'm not sure what happened with the other banks. But, you know, there's no excuse now for any large business that's running standard form contracts to weep and wail that we didn't know about this and da. Well, you know, this has been in place since 2010 for consumers. Wake up. You know, the long and the short, there are far too many businesses there who are only going to do what they're made to do. So now you're going to be made to do it. Ordinarily, in these sorts of laws, there's an implementation period. I haven't actually looked at what that implementation period is, but But once the bill's passed, it then has to be proclaimed. That normally sometimes can take several months. But this has been in the pipeline for a long time, and I don't think that any business has got an excuse to not comply.
Will it be retrospective at all? Will existing contracts have to be amended?
Well, existing contracts should have been amended anyway. And I'm trying to think. The only, I think it was in 2020, they started to apply the law to insurance contracts. And the only limitation that I've seen in the bill relates to life insurance products that were entered into before a certain date. In other words, because I don't think once you've entered a life insurance product, I don't think the insurer can cancel it on you. I'm almost sure. So there's a limitation on that, but really any other contracts, no, there's no retrospectivity as such. In other words, they can't be prosecuted for what was in the past, but so everything's going forward. But any contracts that they've got at the moment, certainly my understanding is that they better change them. And the only restriction on that, from my reading of the bill, I think, is life insurance products. Yeah.
Great. All right. So Ken Phillips, from CEO of Self-Employed Australia, well done on your advocacy. Well done on a win for everyone. And thanks for your time.
Thank you very much.